Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we are dealing with advertisement as it relates to certain adult stores. This is the case of Lion's Den Adult Superstore versus the Secretary of Transportation of Kentucky. In this case, Lion's Den is an adult superstore, and they sell adult things at their store. And they'd like to advertise their store on the highways of our great nation. In specific, they'd like to advertise it by putting it on the side of a 18-wheeler, or a lorry, as our friends overseas might call it. So they want to put an advertisement on this thing by the side of the road that says, come visit our store to anyone who happens to be passing by. So the Secretary of Transportation apparently had an issue with this sign, and we're going to go to lawsuit over it. So let's read about the Adult Den Superstore. Let's get started with this. Lion's Den runs an adult superstore in Upton, Kentucky, located just off exit 251 on Interstate 65. So in case you're looking where to go, the court has told you. This store sells books, magazines, and other items not worth belaboring. That's a nice way of putting it. To catch the attention of potential customers, Lion's Den placed a billboard on a nearby property at exit 251. Attached to a semi-tractor trailer, the sign reads, Lion's Den Adult Superstore, exit now. The trailer is parked on land owned by a former employee of Lion's Den who rents space to the company. So yeah, exit 251, Interstate 65 in Kentucky is where all your adult superstore needs will be filled. They sell books, magazines, and other items. And they want to sell to you. And the court has thoughtfully told us exactly where they are, so we can all go visit together. How nice. So this is the thing. There's some advertisement, and we're going to have an objection to the sign. So let's do that. The sign caught the attention of customers and non-customers alike. One non-customer was the Kentucky Department of Transportation. I'm not so sure about that claim necessarily. I'm not sure who at the Kentucky Department of Transportation noticed, but I'm not sure we can necessarily conclude they're a non-customer, which ordered Lion's Den to remove the sign. As the department saw it, the sign violated Kentucky Billboard Act, which imposes special requirements on roadside billboards that advertise off-site activities, those offered off the premise on which the billboard is located. At stake is whether the Kentucky Billboard Act abridges the freedom of speech in violation of the First and 14th Amendments. It concerns a sign code that imposed limitations on some signs, but not others. The code placed special restrictions on signs that directed people to certain events, but did not apply those restrictions to other signs, including those related to elections. What matters under our case law is whether the regulation restrictions are content-based. If yes, strict scrutiny. If no, not so much. So yeah, we've covered this case in its different forms, different times, and this is basically the standard. First question we have to ask, is the regulation content-based or non-content-based? If non-content-based, then we're normally looking at intermediate scrutiny, time, place, manner restrictions, right? So you could, for example, potentially ban all billboards. Some states have done that because that is not based on the content of the billboard. It applies to all of them, no matter what it is. And you could have other sort of regulations about their lighting and their spacing from the road and sizes of, different fonts maybe or something, depending on location. But once you get into the message of the thing, you have a problem based on content. So the question is this a content-based or non-content-based restriction? A law may be content-based because the regulation turns on the topic discussed or the idea or message expressed. Even if neutral on its face, the law may also be content-based because the regulation turns on government's disagreement with the message, which is often called a viewpoint-based discrimination. The Billboard Act triggers skeptical review based on the first problem, that the regulation turns on topics discussed. Consider the topic-based distinctions drawn by the Act. Billboards that advertise off-site activities require a permit, but billboards that advertise on-site activities do not. Billboards that advertise off-site activities must be secured firmly to the ground, but billboards that advertise on-site activities need not be. Billboards that highlight off-site events may not be placed on mobile structures, like semi-tractor trailers, but billboards that advertise on-site activities do not follow the same rule. In more ways than one, the Act differentiates between billboards advertising off-site activities and those advertising on-site activities. So yeah, we can't really determine whether or not it's on-site or off-site without looking at the message. Because if we're advertising something that's on-site, then that's going to be based on the content. We covered this case recently in Austin, and the court's about to cite it, where the exact same analysis. It's like, yeah, when it's well, how do we know if it's off-site or on-site without reading it? And once you read it, you're in content. So yeah, that's a problem. Because the message on the billboard makes all the difference, the act amounts to content-based speech of regular speech. Our court has traveled this way before. Nice turn of phrase there in this case, traveled. Just this last year, we held an on-premise exception applicable to commercial and non-commercial speech alike in Tennessee Billboard Act made it content-based. Deciding whether the exception should apply, we said, would require reading a sign's message and determining its meaning or purpose. Because the Billboard Act is content-based on its face, it survives only if it runs the gauntlet of strict scrutiny, which no. The Billboard Act does not measure up to this ruler, while the Commonwealth of Kentucky invokes its interest in safety and aesthetics. Our prior case did not find those same interests compelling. Even if it were not the case, even those interests sufficed in the abstract, the Act leaves untouched other billboards with similar qualities. So yeah, it's if aesthetics and safety are the issue, which maybe they are, but once you're talking about the content of the billboard, you might have a problem. So if you're talking about lighting or distance from the roadway or, how it needs to be secured or some other stuff, then, fine. But, if you're looking at the content, maybe not so much. Take aesthetics. Billboards about on-site activities produce no greater eyesore than billboards about off-site. Yeah, without reading it, you literally can't tell what the billboard is about. So it would be exactly the same either way. This is also true for safety. Kentucky has offered no reason to believe that on-site signs pose a greater threat to safety than off-site. Kentucky has admitted that Lions Den Billboard would not affect states' interests any differently if it discussed on-site activity. We do not stand alone in our assessment that billboard law like this one must satisfy strict scrutiny, or our assessment that this kind of law fails the test, and this goes to a case we covered relatively recently. Reagan National Advertising of Austin versus City of Austin applied strict scrutiny to a sign code applicable to commercial and non-commercial speech because it treated on-site advertising differently from off-site advertising. When the City of Austin invoked interest in safety and aesthetics, the Fifth Circuit reasoned, as we do here, the on-site exception made the sign code fatally under-inclusive. Kentucky insists intermediate scrutiny should apply to the Act because Lions Billboard contains commercial speech, proposing a commercial transaction. But we have held that content-based statutes that sweep in commercial and non-commercial speech alike are subject to strict scrutiny across the board. So yeah, fair enough. If this is commercial speech, which might go to content, but even if it does, it's a special category unto itself. We have a special rule for it. So how do you determine if it's commercial or not? You have to look at it. So it's content-based. No, we have a special category for it. So if it's commercial speech, the government can regulate it. Now, those regulations usually have to be around fairness, and they have to be, for example, the communication has to be honest. So you can't lie in advertising. You can certainly puff, and you can, make your product look good, but you can't lie. Then they might have to be some disclaimers on it, depending on the nature of the product, or something. So yeah, and that's intermediate scrutiny too, just like time, place, manner. So you just merely have to have a substantial government interest and least restrictive means, as opposed to a compelling governmental interest and narrowly tailored, which is basically impossible. So if it's commercial in nature, yeah, but the problem is your sign is discriminating based on commercial. Your signs are discriminating based on-premise versus off-premise. Well, that has nothing to do with commercial, or not. It has to do with location. That's not commercial. And that sounds like a time, place, manner thing, but again, we can't determine it without reading it. So it's not commercial speech, even if this example is commercial. If you want to regulate all commercial speech, then great. Then that would apply to the billboard or not. Either way, that'd be fine. But you can't just say, well, because this is commercial, we can regulate it. No, you have to treat all commercial speech the same, and you're not doing that. And this is my personal favorite part of the opinion, because I'm wondering what the court is really trying to say. And here's what the court wrote. Because the definition of advertising device under the Billboard Act encompasses non-commercial speech, Lion's Den could no more place Vote Democrat on its sign than it could place Adult Superstore there. Now, the reason I like this, and it's a favorite part of my opinion, is because they could have used any number of examples. They have an infinite treasure trove to pick from, right? So when they said Lion's Den could no more place blank than it could place Adult Superstore, they could put just about anything in blank. And one would imagine that this is a fairly deliberate choice. It's not just something that went past them. So what exactly is this court saying about adult superstores when it juxtaposes those with Democrats? They're trying to say something. There's a reason they put Democrats and adult superstore in the same breath when they could have chosen anything else. So draw your own conclusions on that one. As International Outdoor recently explained, these principles apply even when the speech at issue is commercial. Kentucky suggests that the permit sought by International Outdoor would have allowed it to install both commercial and non-commercial billboards, which distinguishes International Outdoor from this case, where Lion's Den has erected only a commercial billboard for use so far. Kentucky argues that it does not need to make a showing that the onsite-offsite distinction satisfies strict scrutiny. As for its judgment, a city may draw a distinction between onsite and offsite commercial speech regulations under Central Hudson. That is not the case. The Kentucky Act applies to commercial and non-commercial speech alike, and that's a no-no, requiring us to apply strict scrutiny to the entire Act, and permitting Lion's Den to invoke overbreadth doctrine in doing so. Thus, that brings us to the end of the case of Lion's Den Adult Superstore versus Kentucky's Secretary of Transportation. In this case, Lion's Den Secretary Superstore, located on exit 251, just wants to sell you some adult stuff. And they want to sell you adult stuff and let you know about it by advertising on the side of an 18-wheeler, which apparently is their method of doing it. Yep, okay. And Kentucky has a problem with this because of signing regulations. And the court points out, well, your signing regulations are based on on-premise versus off-premise speech, and there's no way to determine that without reading the speech. So, you can't do that. So strict scrutiny fails. Lion's Den Adult Superstores gets to advertise another day, and that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.